Hello, everyone. My name is Melissa Andre. I'm the Executive Director of the Tax Review Board. We are convening today's hearing on Tuesday, March 17th, St. Patrick's Day, at 2:18. Our Zoom room is quite large today, so I would just ask everyone to be very mindful of when they're speaking and not to talk over each other for the court reporter. I also want to make aware, please be aware that this is a public meeting and it is being recorded. Because the meeting is public, participants and viewers have no reasonable expectation of privacy. By continuing to be in this meeting, you are consenting to being recorded. I'm also going to run through the kind of list of and how we're going to be proceeding. We'll be proceeding with the status matter first. It includes Vinmar, Dew, and the Jen cases. Then we'll be going to case number 1, urban real estate, and then we'll be finishing with cases 2 and 6, Hermano. And I'll give it to our chair, Nancy Kammerdiener. Nancy, please take. Nancy, you're on mute.
Finally, got it. Sorry, it didn't want to come off.
All right.
Good afternoon, everyone. This is Nancy Kammerdiener, the chair of the board, and we're, as Melissa indicated, going to turn first to cases 4, 5, 7, and 8. They are listed on our agenda as Jen David, last 4 digits of the docket, 6726. Also another Jen David or David Jen, I'm not sure which direction that should go, case ending in 6725. And then we have 2 others, Vinmar LLC, case ending in 6745, and Stephen Dew, case ending in 6736. Are those individuals or their representatives here to be identified?
It's Christopher Johnson for the City of Philadelphia.
Good afternoon, James Pearl on behalf of David Jen.
Good afternoon, Lisa Buckaloo on behalf of Vinmar LLC.
Okay, is that everyone from both the city and the petitioners who need to be?
I know there's one other party who's represented. It's Mr. Jason Weiss. He was just trying to log in, and Mr. Warwick Reiser had requested that we.
Okay, I don't know about others, but I'm having a little difficulty hearing you. I can tell, I can hear half of it, but not hear it loudly enough to be comfortable. Can you get closer to a mic?
How about now?
It's a little better. Okay. Did I see someone come in who needs to introduce themselves for the matters on our agenda for cases number 4, 5, 7, and 8? Is that James Pearl?
Yeah, I've already entered for.
Oh, you've already entered.
Oh,
okay,
yes,
my apologies.
No
I'm
problem.
getting mixed up here with the faces going around.
You're fine. Thank you.
In any case, we wanted to identify here what some of the issues were and whether there was a way of reaching a resolution in terms of how we go forward. And I don't know whether it's the city representative or someone representing the petitioners who should be going first on this.
So I had, regarding those collected matters related to the gas explosion down on South 8th Street, there had been 4 appeals that were filed. And the city had sent a request to the board a few weeks ago requesting that all of those matters be put on what we would term as a litigation hold until the outcome of related litigation between the owners of those property and people who may have been injured as a result of the gas explosions and the city. Now, there are 6 cases consolidated for trial purposes in the Court of Common Pleas related to injuries resulting from the gas explosions, which in the city's mind, we're requesting that the board put it on hold for a number of reasons. First of all, some of these appeals are clearly basically tort actions masquerading as board appeals. They're seeking for the board to litigate responsibility for the gas explosion where that's not really, it's beyond the jurisdiction of the board. So there are already pending cases on that issue, which would affect every single affected party as far as litigating those issues in this case. Um, if the board finds one way or the other, if the board were to make a finding, say that the owners of the properties were not responsible or owners of the properties were responsible, that could be brought up as stopping that issue from being litigated in the related cases. And we have um, no offered expert testimony. PGW is also a party in those other cases, and their interests are not going to be represented in this matter. So I think it's the city's position that these should all be put on hold until the close of that other litigation.
Okay.
May I respond?
I was just going to ask if there were any responses to that.
So I represent David, I represent David Jen, and despite my repeated request from Mr. Johnson to call me, that did not happen and has not happened. If you can see on the screen, I was before you guys about a couple months ago. This is the letter that was sent by Mr. Johnson. He says that my client, you'll see on the first two, my client is not a party to any litigation against the city. And I don't know, and when I asked Mr. Johnson to correct that, it seemed sort of that yes, and then he was like, well, it's not. So my client has no litigation against the city. Any decision that is reached by the city, unfortunately, in whatever litigation, cannot be binding upon my client. My client's not a party. So only speaking for mine, which I've asked Mr. Johnson to repeatedly fix, is how can a court to which my client is not a party make a determination that has any effect on my client? Now, if the city's position, which is not, I don't think, is that they're going to say, well, if the court rules in favor of all the other defendants, then it's binding upon Pearl's client, then I win. But if the city loses or wins, then it's not. It has no effect on me. So I can't be tied for my client as to what may or may not occur in a court case to which we're not a party. And I think it's disingenuous for Mr. Johnson to say that. I thought he was going to say everybody but Mr. Jen. And I think he's sort of still suggesting that. We are not a party to any litigation.
All right, so let's go back to Mr. Johnson and get his reply to that.
I definitely would agree with Mr. Pearl. His client is not a party to that litigation, but the issues that are at the core of both that litigation and what Mr. Pearl is going to ask this court to decide, or the board rather, are the same. And so for that reason, collateral estoppel would apply based on a finding by the board in that other case, or by a finding in that other case in the matter before the board. So essentially what Mr. Pearl's asking is it the position of the city that if that court results in a judgment for those plaintiffs against the city, I believe that there's case law that would suggest that if a court makes a finding that the city was at fault for that whole situation, that none of the people involved or affected by the abatement bill, which is the issue before the board, I don't think any of those people should be would be on the hook for the bill.
Counselor,
That's
excuse me, Counselor, what case law are you relying on? Because I believe the counsel for the petitioner is raising a valid point. And if you're saying that ultimately, if this case is adjudicated in this court, his client would therefore be bound by it, and you're relying on case law, we would like to see that. I mean, ultimately, you knew before you came here today that his client was not a part of that litigation. So do you have that case law for us to review?
I don't have a case, no. So, but
And wait, and also, let's so I'm clear, I am not, none of my argument is on fault.
Or is on what?
Relies upon who's at fault. So to the extent that they're litigating fault, F-A-U-L-T,
Yeah.
I'm not. I'm going to tell you, if you look and you'll see the information I've sent, this imminently dangerous condition was closed 4 months after, and I showed it on Atlas and I submitted it. I'm arguing that there should never been a demolition. Not who caused the accident. So they can litigate personal injury, property damage. I'm just here telling you that I'm here about a money lien that I don't believe for demolition, and I don't believe the demolition should have even occurred. And I sent Mr. Johnson the information, and honestly, you'll see when I walk you through in the timeline, it doesn't make sense. The city closed this out on Atlas, the imminently dangerous condition, in March of 2020. On my
Okay, we're
client's
not gonna
property.
go through, we're not gonna go through all of that at this
So I
point.
just want to make sure that we're not here on fault.
That's
so
very
whatever-
helpful.
Yeah,
Thank you.
yeah,
No,
I'm
that,
not-
that really is very helpful.
Yeah.
Melissa, you have counsel.
I
Are there
have counsel for Mr. Jen.
Mr. Du.
Could you identify yourself?
Yes, I was just
yeah,
going to ask.
I
I saw
can.
that was
Sorry
somebody
about
new.
Yes, my name is Jason Weiss of Salzman, Galuzzi, and Vendesky. Steve Wigreiser, I will note, is also on the Zoom. There was
And you're
Yes,
representing who?
I represent the Du family. They were at 1437
Okay.
South A Street. They are the home that was the most impacted. Brian Du is their child, or was their child. He was in the residence and passed away. Their entire home burned down as a part of the gas explosion. We have a very different take on this than Mr. Pearl does. We are quite frankly shocked. It's one of the most surprising things I've seen in litigation since I started practicing, that the city is coming after the Du family for the demolition bill in this case. However, to the extent that the city seeks to continue to bill the Du family, which we would at any times recommend the city withdraw this claim and abandon it, we would say that a litigation hold would be appropriate, as the city has not even begun to produce discovery in our
Okay,
wrongful
So let me
death.
stop you for just a moment.
Mhm.
So you and your clients are part of the common pleas litigation as to fault.
Yes, we are.
And part of that, of course, the bill gets all wound up in that. Okay. So you're in a different posture than Mr. Pearl and his client.
Yes, we
Okay.
are, Your Honor.
And what about Vinmar LLC? Who represents them?
You're on mute, Ms. Buck.
Mute.
You're on
Sorry
mute.
about that. My name is Lisa Buckaloo. I'm an attorney with Zenstein Kowalski Buckaloo LLC. I represent Vinmar LLC. We are in the same position as the latter defendant in that we are in litigation with the city as well. I would say though, we do agree with a litigation hold. However, we also agree with Attorney Pearl's position regarding the fact that the demolition never should have happened in the first place. And if he's successful on that, it should be applicable to my client as well.
Well,
So
that's
just so-
that's a different issue.
I was
But-
about to say, so just so that we have an understanding, so case numbers 4 and 5, which is represented by Mr. Pearl, which is Mr. Jin, are not arguing fault, but they are arguing that the demolition was not appropriate. Case numbers 7 and 8, Vinmar and Dune are both on the Court of Common Pleas matter, and they both are arguing fault. However, Vinmar LLC does want to maintain its right to pursue whether the demolition was valid or not. Is that correct?
Exactly, thank you.
We're
Yes,
not
thank you.
waiving that, and we're not waiving that, Your Honor. I think that what we're trying to say is that we are at a very nascent stage of discovery in what is a much larger piece of litigation, that this bill is for the demolition of a property that exploded, where someone's life was lost. And it may be misguided, it may not be, but our position is clearly that it was. And I think that we, on our case, if this is going to be something that the city is actually going to pursue, then we need time to conduct discovery.
So as long as that matter is still barred against your client, you would like to continue to pursue any type of argument that the demolition was not valid as well.
That's correct, John.
Okay.
And just to be clear, the city's position, I'm listening to this argument that we're going to argue about whether or not the demolition should have happened. and we're separating that out from fault. I mean, the city is authorized in the code. It's black letter law that if there's an imminently dangerous condition, they're authorized to do an emergency abatement, which is exactly what happened. So
We don't have those
to
facts.
say it's not related to fault, I think is a little bit misleading. I mean, and here there was an emergency abatement. PM 110 requires the city to bill the affected property owners, period. The city was simply following the law. And these sorts of arguments about whether the city should have done the demolition, you should appeal that if you disagreed with the ID violation. This isn't the forum for that. That's the Board of L&I review. And unfortunately, there was an emergency abatement. The city has to bill people for it. That's what the law says. So I don't understand how you could pull away that, well, we're not saying it's fault, but we really are saying it's the city's fault.
Right now, and that the evidence on those matters are not yet presented to us. So closing argument is not yet in front of us, essentially. So do any of the attorneys for petitioners have any final remarks before our board members, I guess, have a discussion about this?
Yeah, Ms. Weiss, my name is Steve Wigriser. I also represent the Dew family.
Okay.
Yeah, along with Mr. Weiss.
Mhm.
I'm just wondering whether Mr. Johnson will concede that if the city is at fault for the explosion, that the billing would be inappropriate and they would not be entitled to reimbursement.
I think that's yes. The city's position is if the court were to find, if we were to litigate the other case that's been consolidated and there's a finding for the plaintiffs in that case, I don't believe that the individuals affected should be billed for the abatement.
And that would be even those who may not be parties to the litigation?
That's
You're willing
correct.
to do that on the
That's
record?
correct. And I believe the records show that there were 6 properties who were affected. I know Mr. Jen is not involved in the litigation, but it was all part of one abatement. So I think the city would carry that through. If those parties were not on the hook for that bill, then neither should Mr. Jen be.
The problem that council is creating, and maybe he didn't think this through, is now you want me to intervene and watch. So I have to hope that plaintiff's counsel in litigation in state court win. Why would I do that?
Well,
I have to,
well,
wait, I have to intervene and make sure that they win so that it's binding on this.
I'm not sure that's what he was saying,
Well,
but
but wait, I have to put, why would I let my client be bound? I don't know what they're doing up there. I don't know how they're going to try the case. But
I understand that, Mr. Hope, but we're not talking about dismissing this matter in front of the board. We're talking about whether we're just going to hold it in abeyance for right now. Your clients, we're not talking about having your clients lose their opportunity to still make an argument in front of the board, regardless.
my clients have due process. So just so we're clear, my client has a due process right to have this adjudicated. And what you're essentially doing, timely adjudicating, is saying, we're going to wait for a case to which you're not a party to determine if that has any effect on this case.
That is not an unusual posture that this board has taken.
I'm not willing to agree to that. It's
Okay.
not res judicata. I'm not a party. I can't be bound by that. Collateral estoppel. How? I'm not a party. I'm
And
not. a
Mr.
Catholic.
Pearl and Ms. Weiss, I want to be clear. I was asking that question solely with respect to the Dew case.
Yes, we
I wasn't,
understand.
We
I
understand.
wasn't implying that Mr. Pearl would in
Yeah.
any way waive his right to a prompt hearing.
No, we
or give up
understand.
any of his defenses.
We understand, but Mr. Pearl's just trying to advocate for his point that he would like, if we're going to do a litigation hold for the other 2 cases, it would not affect his case being able to proceed forward. We understand what you're requesting.
Right.
And we
And I-
will
and I
go
don't-
back and confirm.
And I appreciate where we're at, and I think you sort of get my frustration. I was here before the board, and the chair asked us to continue that. We were in person. We didn't know that Zoom was an option. And my understanding was that the chair gave us time and to communicate with counsel. I thought that that was the guidance I was getting. I have received 0 phone calls. So my frustration is, this is now the second time I've been before the board. And at this point, I would just like the board to hear my client's case. I thought that we gave me time. I
Mhm.
never heard from Mr. Johnson. I got that letter, which really was not accurate and was not clear. I then called him. I was a lawyer for the city law department. He did not return my call. So
Okay.
I'm
Right.
tired of the tactics. of Mr. Johnson.
We hear your frustration.
Yeah,
we-
that's
we
terrible.
do Understand.
And I believe there's one more point coming, and then we're gonna have to go back to the back to
Thank you.
confer. Yes,
I'm sorry, it's Mr. Weiss, not Melissa Andre, who is, I appreciate her letting me sit in her chair. I would just like to note for the record that the city is a party both in, and I see that there's a court reporter, and I will request a transcript of this hearing. The city is a party in both litigations, and we have respected the city to the extent that we weren't quite sure what this bill was or what their intentions were with respect to the litigation that is companion to this, the wrongful death and survival litigation. And we have claims in that case which relate to the subjective intent of the city with respect to the fact that Brian Dew is not the first person that has passed under these circumstances, and is not even in the first 10 people that have passed in the last 10 years from one of these gas explosions. The Dew family is not the first Philadelphia citizen or resident to experience this type of tragedy because of the gas lines that are old and decaying and failing under this city. And we are very, very much disturbed by the manner in which the city is litigating this portion of this litigation away from the wrongful death and survival suit. And I just want to make it clear that we gave the city an opportunity to consider their position with respect to the Dew family, and that if they continue to move forward in this regard, we will consider this as part of all actions, not separate.
okay, so thank you for that. Are we ready to go to the back board?
I think so.
I believe so. We need Melissa back.
Come back, come back.
Mr. Weiss.
There's 1 second. I'm sorry. I just want to. Well, everybody can just hold tight. The board is going to go back into the break room, and we'll be back out. Thank you, everyone, again, for your patience.
Great, thank you.
Before my board starts tapping away. Come on, you go into the room.
Is there a way to put plaintiff's counsel in a break room? I guess that request is too late. Okay.
Remember, Melissa, when I said I hate your job? I definitely hate your job, especially
Today is a
today.
really rough
I
one.
know.
I got my.
I'm ready to go back in person.
Well, Mr. Weiss is there in person.
I know. I've done that. I was there before that, but the board is not in person. So
And the
it's,
Dew family is there in person.
I know I see it. It's hard to do. No disrespect to you.
And Mr.
I had
Jen,
a wonderful tour of the tax advisory board today. I appreciate everyone.
is there a way, I guess, I missed the opportunity. I wanted to get into a break room, but I guess that's not going to happen.
I think Melissa has to set up the breakout rooms. Can I get the spelling of the Dew family?
Yes, it's DIU. Do you want their first names as well?
No, I think I only have the Dew family on the record. That's fine. Thank you.
Welcome.
Well, it looks like my audio is off. Is Jason Weiss still in the room? I just want to let you know, if you want a transcript, you can reach out to Strelo Court Reporting.
Is that STRAHLO?
STREHLOW. They have
Okay.
four offices in your area. And let's see a good number to call them.
I mean, if I give you my email address, is the request going to come to you?
No, it goes through my production department. So you can give me your information. I'll have them contact you.
Absolutely, that works for me. My email is jweiss@smbb.com.
SMDV.
S like salts, M like Mongoloozy, and B like Bendeski, and then B again like Bendeski. So smbb.com.
Great. I'll let them know. Jennifer will reach out.
Thanks so much.
Mhm.
Chris, I had tried reaching out to you to discuss this ahead of this time. I'm obviously not putting that on the record, but if you would like to talk at any time, so please feel free to reach out. Okay.
Okay, I'm not involved in the other side of the cases. I'm just here on the board appeals. So
I understand, but I don't think this is a Chinese firewall type situation. If you would like to speak about this at any time, please let me know. All right, I'll give you my
All right.
email, my cell phone, my work line. I think that this is something that we should probably discuss before we go on the record again.
Okay.
Paula, Nancy, okay. Everyone is back. Paula?
All right, we're going to go back on the record. Thank you all for your arguments and information. We had a discussion of everything that we heard, and the decision is going to be as follows. Excuse me while I look away to my other screen so I get everything correct. Cases number 7 and 8, ending in docket numbers 6745, 6736, which are Vinmar LLC and Stephen Dew. We are going to place a litigation hold on those and put them aside for right now. Cases 4 and 5, David Jen, we are going to hold separately. We're going to ask for two things, gentlemen. We are going to ask for letter briefs on the issue of collateral estoppel so that we can see and review any case law or information that you can provide for our board on collateral estoppel. And we're going to ask for those within 45 days. In addition, we are going to ask that the two of you actually communicate and try to come up with a stipulation of facts, recognizing that there may still be disputes as to some of the facts, but a stipulation of facts as to those issues that are not in dispute. We are also going to set a date certain for a hearing before the board to hear any evidence and argument that are still in disagreement regarding the appropriateness of the bill sent to David, Jen, and we're going to direct that you work with Ms. Andre as quickly as possible to settle on a date certain for the evidentiary hearing so that we can get that case moving along.
Please note, Mr. Johnson and Mr. Pearl, Mr. Pearl, I'll be reaching out to you to email. We're currently scheduling in June, but I'm anticipating a July, August, or September date.
Okay, can
Thank
I
you.
ask a clarification? I'm not sure I feel comfortable with us giving briefs. I mean, I'm not interested, and I don't mean in a disrespectful way. I'm not sure I'm comfortable, either me or Mr. Johnson, providing law on collateral stop. I'm
That's
not,
going to be an argument that either party is going to make. The board's going to be requesting your basis for making the argument.
The argument that the city has about estoppel is that it can be raised against a party in a future proceedings.
That's fine, but we would like
Right.
to see whatever case law you're relying on for that. And if Mr. Pearl, you would like, listen, you don't have to if you don't want to. That we'll only have the city's side of it is essentially where that's going to go. So we would like to know where both sides stand on whether that issue is going to be a stumbling block or not for the board going forward with the knowledge that we have of other ongoing litigation.
Ms. Weiss,
Right,
also, I would ask that we be copied, even though we're in litigation hold, on any filings within these other cases, because my concern is that the outcome of those cases will somehow be raised as collateral estoppel in our review board matter at some later date.
All right, well, we're going to wait. I think we might hold that in abeyance, Mr. Wigrazzer, and see where we go with this issue right now.
Ms.
But
Weiss, I'm not terribly comfortable, and I keep trying to say this. I'm not comfortable with me advising the board or Mr. Johnson advising the board on what we think the law is on collateral estoppel. I mean, we're advocates. We're going to
Well, are you going to make an oral? Are you going to make an argument or not when you
about.
get in front of the board? Are you planning to argue in front of the board and present your position when you get to the board for a full?
I don't believe that anything that the board decides with regard to the charges that are levied for the demolition against my client, stop any. I mean,
Well, that's fine, but we would like to know the basis for your making that statement and asking us to find in favor of that position.
I mean, I think that to put it succinctly, I think what Mr. Wigreiser was thinking about was when the board ends up finding that, yes, there was an emergency abatement and your client should be billed, could that be construed in the future proceeding to preclude any relief on that issue in the other cases?
That's not my
That's
argument.
collateral estoppel, right?
Right, but it's not I'm not like, I can't, and I
I'm
respect.
sorry, I'm gonna interject.
Okay, let's
This
take a
is why
step
we
back.
want the brief.
Yes, let's take a step back. And this is going to be the final comment on this issue. Our tax review board member Weiss has already told you what our ruling is. Just to be clear, the reason why we are asking for this is because the argument was made at the top of this hearing that the reason why the litigation hold should be in place for all parties affected is because ultimately the outcome of the litigation of the Court of Common Pleas case would bind Mr. Pearl's client. We need you to brief why that would not happen in your case, Mr. Pearl, and you need to brief Mr. Johnson why that would happen in this case. As a
Thank you.
result, that's a threshold issue. We want to get over that, do a set of stipulated facts so we can have a very succinct hearing when we actually have our day in court. As it pertains to the other two parties to this, cases number 7 and 8, we will reserve your right to pursue this issue based on the pending litigation that's happening in the Court of Common Pleas that is on the record. I know you want a copy of the materials, but we don't want to misrepresent that you're going to get them simultaneously. You probably will not. But ultimately, if you contact Miss Andre, she will send them over to you as we receive them as well. You know, in 45 days, we'll receive them. I would say you calendar to send her a note so that way she can send you an email with those items. That is it. This is over. Next case, please.
All right, thank you, everyone.
Thank you.
All right.
Thank you.
Um, I think,
Nancy,
should we
I
take
think
are we
But
ready
I-
to announce the next one?
Yes.
Okay, it's, the next case is on our agenda as item number 1, urban real estate investor. Last 4 digits of the docket, 6909. It involves the property address at 4610 Benner Street. Who has this matter for the city?
Good afternoon, Amy Skiles on behalf of the City of Philadelphia.
Okay, will you have anyone testifying or presenting who needs to be sworn?
Yes,
Richard Wade, litigation support, license and inspections.
Do you swear or affirm to tell the truth with everything that comes before the board?
I do.
Okay, thank you.
One moment. I'm getting the petitioner settled.
Okay, fine, thanks. Good afternoon, welcome to the Tax Review Board. Please identify yourself for the record.
My name is Janina De Souza.
If you could come a little closer to the computer, that's where the mic is, and it will help us to hear you a little bit better. If you would just give your name again, please.
My name is Janina De Souza.
Do you swear or affirm to tell the truth with everything that comes before the board?
Yes.
Okay, thank you. As you were coming in, I kind of jumped the gun on it. I asked the city people to identify themselves. And so if you could identify yourself again, that would be city's council and then the person who's going to be providing additional evidence.
it's Amy Skiles on behalf of the City of Philadelphia.
Okay. Do you have any opening comments?
Well, my witness who would be testifying to the violations and abatements is unavailable today, so I would be requesting a date on this, a continuance on this matter.
Oh, okay. We didn't know that that was going to be coming up. So you don't want us to proceed with anything today in terms of providing background or anything else? Is that correct?
That is correct, and I apologize.
So before,
Yeah.
This has been continued once before.
On whose part? Where's
The petitioner's behalf. It was a property manager had appeared at the last time this was listed, and they did not have a power of attorney. So it was
There is a
continued.
power of attorney. I'm sorry. There's a power of attorney. I will email it to you. I didn't know which attorney it was. Give me a second.
Melissa,
did you communicate this request for a continuance to the petitioner prior to today?
I did not.
Petitioner, do you object to this?
Oh,
Mr.
Are you
Souza,
objecting to the city's request, or are you in agreement with the city's request for a continuance?
I mean, I waited here for an hour for this. That's fine for continuing.
Okay, so Melissa, just because I know you were out, the city's witness is unavailable today. The petitioner is willing to agree to the city's request for continuance, but they want to do a date certain next.
This is an $82 case. I'm sorry. What do we need a continuance for?
My
Today's
witness.
hearing.
Oh,
The
your
city's
witness.
witness, the city's witness is unavailable.
Okay, I understand. I can give a date certain.
right, Ms. Skiles, could we in the future request that in these circumstances, you reach out to the petitioner ahead of time and let the board know also
Yes,
ahead of time? And certainly at the beginning of the hearing, speak up so that should there be someone here waiting, that they don't sit for an hour.
yes, absolutely.
And the petitioner, the next time you can attend by Zoom as well. That way you don't have to come down here again, as you've already submitted your power of attorney.
Right, hang on a second. Mr. Wade, did you want to jump in here?
If Mr. Howard needed to stand in for the witness, it's a small bill. The case should speak for itself, and it's up to her. If she wants me to stand in for the witness, I can.
You have the information, you have access to the information.
Yes.
Right?
Yes, it's not that big of a, I don't think it's that big a deal.
All right, hang on, Mr. Souza.
She feels comfortable.
Do you need to talk for a minute?
No, I can proceed with Mr. Wade.
Great, let's go,
I'll read the numbers.
please.
This was for a clip abatement, July 26, 2019. Bill amount and principal, $60.93. An administrative charge of $12.79. Interest, $11.58. The total amount due, $85.30.
Nancy?
Does the petitioner have anything to tell us about this matter and why it is you're pursuing this before the board?
I don't have anything else to say. To be honest, this appeal was done by the previous property manager. He is no longer with the company, so.
Are you still questioning the bill?
I was told to come to this hearing and.
Can you speak up a little bit?
I was told to come to this hearing and here I am. I don't have any more information.
Thank you. All right, City?
Yes. So I would just call Mr. Wade briefly to present our case.
Very briefly.
Yes. Yes. So Mr. Wade, are you familiar with the property 4610 Benner Street?
I'm familiar with the area. I used to be an inspector about 6 or 7 years ago.
If I may just share my screen, I'll show the notice of violation. Okay. 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 So just Mr. Wade, what is this document that we're looking at?
This is a notice of violation that was sent for overgrowth to 4610. I believe the date, it appears to be May 7th, 2019. And it just states that the grass or in the surrounding property was over 10 inches high.
Okay. And then I just want to scroll down and one of the last lines of the notice of violation, how many days were the petitioners given to comply with this notice of violation?
10 days, I believe.
10 days. And do you know the date of abatement for this property?
Give me 1 second. July 9th, 2019.
Okay, so the notice of violation was in May and it was abated in July, well after the 10 days given to the property owner to abate those violations on his own.
Yes.
Okay. And if I may just scroll through the series of pictures, as an offer of proof, these were the pictures taken in May at the subject premises.
Yes.
And then once again, these were taken in June at the subject premises.
Yes.
Scroll out. Okay. And then this is how the subject premises appeared on July 9th, the date of abatement.
Yes.
Okay. And then finally, after the property had been abated.
Yes. Not that one, below it.
Yes,
That
the one
hasn't come
below.
up.
Yeah, I
Here.
don't see it.
Can you see this photograph?
That's the before. You have to scroll down a little bit further, I believe.
Let me see. There.
Do you have one that's after the abatement?
Yes, I do. It's
You want me to pull it up?
It's appearing on my screen.
You have to remember to share your screen or share that.
All right.
There we go.
There we go. Okay.
Thank you.
Can you see? Okay. And this would be the photograph after the abatement.
Got it.
Okay.
Okay.
And so then I have no further questions and no further evidence. I would just ask to mark and
And
move.
what was the dollar amount again on the abatement?
The full breakdown? Or just the,
Whatever
full
we need to know.
breakdown.
the labor was $60.93, the administrative charge $79, an interest of $11.58. The total amount was $85.30.
And there
Okay.
was no external grass that had to be mowed. It was only that front patch.
I believe it was overgrown in the rear, but it was locked. That was what I saw on the notes when I researched it.
Okay, so the only work done was.
The only work was in the front.
Okay. All right, do we need to step aside?
I guess so.
Yep, okay. If everyone can just hold tight.
Come on.
Hi, can I get the spelling for the petitioner?
Yeah, my first name is Janaaina. My last name is Desousa.
Sousa. Okay, thank you, ma'am.
Okay.
Nancy, everyone's back.
There we go. I was having trouble getting unmuted. Okay, the board has reached a decision. It's our decision to deny the petition. You'll get a letter from us that spells out our decision. Both sides do have the right to appeal to the Court of Common Pleas within 30 days of the date of that letter. But I'm going to assume for the moment that neither side's going to choose to appeal. And in that case, then the petitioner should make arrangements to make payment on the outstanding obligation. Thank
I
you for
concur.
coming in today. Sorry you had to wait for a while. And I'm being reminded that my fellow board members need to indicate that they've concurred on this matter. Paula?
Always, I concur.
Dominic
Dominique?
Ward, I concur.
Okay, and as the chair who just identified it, I concur as well. So again, thank you for coming in. Sorry you had to wait so long, and we hope that this issue can be resolved pretty quickly. Thank you. We have two other items on our agenda. There are items 2 and 6 that are both with John P. Primiano. Therefore, an address at 801 Schuylkill Avenue. The docket numbers end in 9260 and 6831. Who has this matter for the city?
I do, members of the board, Jeffrey Cohen for the city of Philadelphia.
Okay, and is the petitioner here? Or
Yes,
someone representing the petitioner?
yes. Can you hear me?
Yes, and
Okay.
please identify yourself.
Michael Forbes, attorney for petitioner John Primiano. Mr. Primiano is sitting behind me because of the configuration of my office. And
We'll ask him to identify himself for the record.
Good afternoon, I'm John Paul Primiano.
Do you swear or affirm to tell the truth with anything that will come before the board?
I do.
Okay, if you are going to be testifying, we would ask that you find some way to accommodate to be closer to the microphone because you'll otherwise be hard to hear. You don't have to do that immediately, but if you're going to be speaking at any length, that would be appreciated.
Yeah, we could switch seats though. I've done this before.
Does the city have any other persons who need to be identified for the record who will be testifying? Who,
Yes, Supervisor Thomas Rebekowski.
okay, if he could identify himself for the record, please?
Thomas Rabakowski, City of Philadelphia, License and Inspections.
Do you swear or affirm to tell the truth with everything that comes before the board?
Yes,
Okay, thank you. And do you need numbers for the record from Mr. Wade?
Yes, please.
Okay, if we could get those numbers on the record then, please.
You want both properties or both bills or?
Are these together or they're both for the same property?
They're for the same property. They're two distinct actions during the same abatement of unsafe conditions.
Okay, so however, it can be most clearly stated for us so that we know what the numbers look like. They could be
Jeff, you-
together if that's appropriate or separate.
Jeff, I'll read the demolition first.
Thank you. Yes.
Okay, I have a demolition bill, the bill date 1/8/2020. Bill amount in principal, $164,700. An administrative charge, $34,587. Interest, $28,896.48. The total amount due, $228,183.48.
And now for the additional work bill.
Additional work bill. The bill date 1/3/2020. The principal $19,899.20. An administrative charge of $4,178.83. Interest $3,009.75. The total amount due $27,087.78.
Would you repeat that total, please?
$27,087.78.
Okay.
I'm sorry.
Thanks, Richard.
Okay, does the city have any opening comments before we turn to the petitioner?
Yes. Actually, there's probably a lot more that we agree on here than we disagree. And it's in writing, which is nice. So there was a Court of Common Pleas case that adjudicated the unsafe violations. There was a final order by agreement that the parties entered into at the end of that case. And as a result of that order, the petitioner and the city agreed that if the petitioner didn't have the unsafe conditions remediated by July 5th of 2019, that the city could move in and abate those conditions by demolition. That's what the city did in this case. Per that agreement, the city also agreed that it would abate the 21% administrative fee, which we are willing to do today. And also, sort of to match, we would agree to abate 21% of the interest, though technically, if you were to abate the interest that accrued on the 21% administrative fee, it would be 17.4%, but we're not going to squabble over the additional few percentages. So I think we would be willing to agree to, again, abate the 21% admin fee, abate 21% of the interest, and per the final order by agreement, the city is allowed under that agreement and by law to charge the costs of the abatements. The two abatements being the demolition, and because there was asbestos found on site during the demolition, the additional work bill, that 19,000 and change, is actually for the remediation of the asbestos. And sorry, that's an offer of proof. Supervisor Rebekowski can testify to that, and those exhibits are part of the city's packet.
I'd like to be a little clearer about something. You indicated that this was in court and then these agreements were reached. How does that differ from what is before this board, or what portion of it is before this board? I'm just not real clear on it. Maybe it's me and the others have understood, but I
No,
wasn't
it's,
quite clear on what we were addressing.
Chair, it's actually not only you that's a bit confused. I'm personally a bit confused as to what's remaining in dispute here. Because we do have that written order, and it pretty clearly lays out what is to be charged as costs and what is not. And we're willing to abate what's not, and we would like to have what is per the order, the cost of demolition and abatement. We would like to have those affirmed.
Okay, we'll turn now to the petitioner to hear why they're here, what they're looking for from this board, and then you can come back on with anything that you need to add that would help us to understand the matter from your perspective. So let's turn to the petitioner.
I appreciate it. The reason we're here is because the order required us to file an appeal, a timely appeal, in order to get the 21% administrative fee waived. So we did not get a bill in time, and we ended up filing the appeal. The city agreed when we filed it, and I have that in writing as part of my packet. Mr. Philbin from the city that, you know, was considered timely filed. So we're in agreement, and I see council's nodding his head that the 21% comes off the top. But had we not done this, that wouldn't have happened. So that's part of it. The other part of it is too, we were never billed. I mean, I did get an invoice last October. You know, I was discussing it with council, and I finally got the invoices from Mr. Philbin. I forget, I think it was last October. It was the first time we were billed. I had discovered the liens on the property, which were put on, they were not supposed to go on for at least 30 days from January the 8th of 2020, but they went on, the liens were placed within that 30-day period. I only discovered it because we had to run a title report because of some financing we were getting on the property. So to be charged interest from any date at this point, although I understand why the city's doing it, it's just inherently unfair because we were never given the opportunity to pay this originally, and then we had to file the appeal to try and get this worked out. So that's one issue right there. And also when the interest would begin accruing if you are going to impose interest. I would say it was this past October when I got the invoices finally. The other part of it is the asbestos. My client, this property, my client bought it in I think the early to mid 2000s. The property consists of an open lot outside, and it was an old building with piping inside that had no asbestos around it. And the walls on the inside and the walls on the outside were the same. There was no insulation. My client will testify that, you know, as far as he knew when he bought the building, he bought it from the University of Pennsylvania. He did it, got a phase 1 and phase 2, although that bank has since been sold and we were unable to procure that there was no asbestos. Nobody ever gave us a report on asbestos. We sent in a lot of pictures. Some of the pictures just show the post-demolition, excuse me, or that halfway through the demolition, showing that the building, you know, how the side of the building was, that if you look at it, you'll see that there was no place for insulation. The inside of the building, the pipes don't have asbestos on it. I know it's a little difficult with these pictures. So we're perplexed as to what this asbestos was. The other part of it is whatever company did the demolition never removed the debris. I mean, the place is a mess outside, and I have pictures, you'll see them. There's bricks laying all over the place. They put stones on the sidewalk. I mean, whoever did that demolition, JPC Group, did not even complete their job. So now we're being charged an extra $19,000. We've never seen a report. We didn't get the bill in a timely fashion. So we don't think that we should be paying that. We were told originally, and we had conversations with Mr. Ribikowski, that this was going to come in. The bidding was about $160,000. That's what he was being told. My client had also gotten some bids around that. And we made the decision, let the city do it so that we don't have to have the city come in after the fact and say, oh, well, you didn't do it right. Now we're going to impose another violation. So the city did it, which was great. And, you know, we have the money to pay them, the $164,700. But this extra added money, and also, by the way, you should know, at least from my calculations, $39,643.39. $39,643.39 would come right off the top for the the waiver of the 21% administrative fee. I haven't figured out the interest. This is the first that I knew of that amount of interest being imposed on that. I mean, it seems really high, but the bottom line is the main reason we're here today is the waiver of the 21%. And we want to see why there was, a claim for asbestos. I mean, this should have been disclosed to us early on, so we could address that and at least examine and inspect the property.
Do you have anything else to add, Mr. Primiano?
Well, I could put testimony on for Mr. Primiano. I mean, we sent in a lot of pictures. I'm not the greatest at technology here, although I've done it before. I may screw this up in terms of bringing up the pictures, but I believe that the board members